and on TuneIn, iHeart, and on Odyssey. This is Chicago's Morning Answer with Dan Proft and Amy Jacobson on AM 560. The Answer.
Top of the morning, Dan and Amy. There's an old adage among lawyers, Amy, and I know you love old adages among lawyers.
And I love lawyers, yes.
Yes.
I have
Lawyers
a lot of
in
them.
love, Jackson Brown.
I have a team of attorneys, yeah.
If you have the facts on your side, pound the facts. If you have the law on your side, pound the law. If you have neither the facts nor the law, pound the table. That's what we've seen over the last week from the pro-abortion ranks, pounding the table. Testimony before Congress last week on the Texas heartbeat law from this abortionist from Texas.
SB 8 has not only caused a near total abortion ban in Texas, it has made it extremely dangerous to be pregnant in Texas, where our maternal morbidity and mortality rate is already unconscionably high, especially for Black women and pregnant people of color. Texas deserves better. I know firsthand that abortion saves lives. For the thousands of people I've cared for, abortion is a blessing. Abortion is an act of love. Abortion is freedom. We need federal protection now. We need laws that elevate science and evidence and recognize the dignity and autonomy of people accessing care. The Women's Health.
Yeah. Abortion saves lives, act of love. Abortion is freedom. It's straight out of 1984, just about. She mentioned people who get pregnant. Yeah, that was the testimony as well of Maliha Aziz from the Texas Equal Access Fund.
And I just wanted to acknowledge a lot of people are being left out of this conversation today because, as we know, people get pregnant and not just women. But I hear people over and over again say women get pregnant. But that's excluding people that should be a part of this conversation.
Exactly. Men get pregnant too now. We know that.
What is wrong with people?
Billie Eilish, the pop singer.
Yeah.
She was in Texas for a concert, and she thought about not going because of the Texas heartbeat law, but she went anyway so she could rant at the crowd.
That when they made that law, I almost didn't want to do this show. So,
No, stay.
because I wanted to punish this place for allowing that to happen here. But then I remembered that it's you guys that are the victims, and you deserve everything in the world. And we need to tell them to shut the up. Do this.
Give the finger to Texas.
My body's my choice.
Oh, really? Not if you're in a vaccinated, mandated union.
She's a delicate little flower, Billie Eilish. But, is that really any different than you get from members of Congress? Alejandra, AOC, the Socialist Spice Girl, front girl. AOC dressing down Dr. Ingrid Skop, who's a Texas-based OBGYN last week.
I need to correct and address an assertion that was made not too long ago. This idea, this myth that, first of all, that this law, SB 8, provides ample time for a victim of abuse to seek abortion care. Because once again, we're in a room of legislators who are attempting to legislate reproductive systems that they know nothing about.
Really? She was addressing an OBGYN. Reproductive systems that you know nothing about. Oh, and this is not the proper venue because this is a sacrament abortion, and so it's beyond the reach of the legislature. No, it's not. That's not how it works. But again, when you have neither the facts nor the law to pound, you pound the table. And that's the table pounding you heard last week into this week. By contrast, Justice Samuel Alito spoke at Notre Dame And he addressed some of the table pounding that's going on and how baseless it is. The idea that taking the Mississippi case, which the Supreme Court will hear this term, was nullifying Roe.
Here is a line from a recent piece talking about our refusal to grant an injunction in the Texas abortion case. Quote, "The conservative majority on the Supreme Court was so eager to nullify Roe v. Wade that it didn't even wait for oral argument." Ends quote. Now, put aside the false and inflammatory claim that we nullified Roe versus Wade. We did no such thing, and we said that expressly in our order. I quote, "The applicants now before us have raised serious questions regarding the constitutionality of the Texas law at issue. This order is not based on any conclusion about the constitutionality of Texas's law. So the statement is flatly wrong, and the suggestion that we should have held oral argument is ridiculous."
Well, that's about what you get from the Atlantic. I correct myself. Obviously, he's referring to the refusal to enjoin the Texas law, not the Mississippi case that the Supreme Court will hear this term. He also went on to address conspiracy theories emanating from those pounding the table, because when they're not, emoting and hysterical and denigrating, they're conspiracy theorizing.
My point is that the media and political talk about the shadow docket is not serious criticism. It is related to a deep problem that some of my colleagues have addressed recently. The catchy and sinister term shadow docket has been used to portray the court as having been captured by a dangerous cabal that resorts to sneaky and improper methods to get its ways. And this portrayal feeds unprecedented efforts to intimidate the court or damage it as an independent institution.
For more on all of this pro-life business before the court, pleased to be joined again by Professor Helen Alvaré. She is the Robert A. Levy Endowed Chair in Law and Liberty at the Antonin Scalia Law School at George Mason University. Professor Alvaré, thanks for joining us. Appreciate it.
Thanks for having me. That was quite the montage.
Quite the montage.
A lot in that. Go you.
Yeah, thank you.
I say it every day.
Well, I mean, it's an interesting divide. People should hear how one side prosecutes their case versus how the other side does, and see if you think that one is being more reasonable than the other. Make your own decisions, I suppose. If you want to go with Billie Eilish, go with Billie Eilish.
Right.
But with respect to what Alito was saying about the Texas law, first of all, the Texas law is not before the court, just to be clear. And let's get to what is before the court, because there's an equal level of hysteria around the Mississippi case. The court will adjudicate this term. And here we have a law in Mississippi that bans abortion after 15 weeks. Mm-hmm. And this is, again, a question of viability, because the court has said any pre-viability restrictions are unconstitutional. And so you have the question of whether the court will draw the line at 15 weeks, as is the case in Mississippi.
Right. So, yeah, Mississippi is making the point with science, with evidence, that there is pain capable in the child at 15 weeks. The Supreme Court's current Roe-Casey framework might even allow a state to say, even if abortion remained a constitutional right, the state has a compelling interest sufficient to overcome those rights in some cases, and its interest here is in not creating extraordinary pain for a helpless human being. Or the court could say the whole underlying framework of Roe and Casey is clearly made up out of thin air, which it is, and we're just going to take this opportunity to be done with it, because banning any kind of regulations like this pre-viability is clearly permissible, and there's no such text in the Constitution or even any way of dreaming it up in the Constitution that the right to abortion exists in the way it has.
Well, and so then, the potential for the latter event to occur, the court to offer that holding. How do you assess that after what Roberts did in the Louisiana heartbeat legislation case?
Right. Yes, I am like a schizophrenic on this. I am of two minds at all times. On the one hand, we have a court who has, in the majority now, often shown itself very responsive to the Constitution and unwilling to make stuff up. And people who look at it and say it ought not to be just what the vote of 5 people say. And if you look at Roberts' opinion, I don't want to just look at what he did on other abortion cases. If you look at what he did in the 2015 same-sex marriage case, Obergefell, he said, we have no history or tradition of same-sex unions being called marriage in the United States. This is ridiculous. The majority opinion is unrelated to the Constitution. You have to look at what the country has done for hundreds of years. That should give people who are pro-life tremendous hope that he would render a similar analysis regarding abortion. But given what you say and given what we've seen that he has done, particularly in the health and safety guidelines cases, in abortion, we worry terribly on the pro-life side that his concern is more about, avoiding pro-choice mayhem on the steps of the court, which, by the way, they will do at the drop of a hat. The sky is always falling in pro-choice world, right? And the slightest implication that unlimited abortion for any reason, at any time is even slightly to be restricted, instigates panic, as I think your montage showed by the statements were so unreasonable and kind of is actually disturbing. And we're worried that Roberts will say, well, precedent is precedent. We've got these cases. Roe has been reaffirmed. Casey's been reaffirmed. I just don't want to overturn precedent because it's bad for the court's legacy, or there's a mob outside the court and I find them influential. We are worried about that.
And the more Solomonic decision that could be reached, which is the Mississippi legislation is constitutional, but
Yes.
perhaps something like Texas heartbeat bill or like the Louisiana heartbeat bill would be problematic if challenged.
There's a way that you could uphold both of them. I mean, again, whenever there is a right that is declared to be a federal constitutional right, the way the analysis goes is, all right, you've got a fundamental right here. Of course, we dispute that, but let's say that's agreed. We've got a fundamental right here. States can only overcome fundamental rights, free speech, religious freedom, etc., if they have a compelling state interest. One could find that the Supreme Court says, a human being with a discernible heartbeat, the state can say, wow, like they used to be able to say pre-Roe, it is a terrible thing to empower the medical profession to take life instead of give life. It is a terrible thing not to preserve, the state's value in unborn life. I mean, states have protections for plants and animals against destruction. We're going to allow them to have protection against either a 15-week unborn life that can feel pain, a 6-week life that has this heartbeat. It would be terrible to deny that states could champion life at this stage. There is a scenario under which both laws could stand, even if, as you say, they do the Solomonic
Right.
baby splitting and say that Roe and Casey still stand. It's just that you can have way more laws than we previously thought under those cases.
But then Roberts would be, if he were to vote it with the majority in that instance, that scenario you play out, he would be reversing himself from the Louisiana case after he reversed himself in the Louisiana case from the Reno case prior to that.
Yeah. He's become sort of less predictable vis-a-vis the Constitution itself and the expected way to interpret laws, and a bit more predictable regarding I need to uphold the legacy of the court from those who would claim that it is trash. Now, pro-lifers who are saying, listen, you've got an opinion that's never been accepted. Every year that NARAL puts out a magazine, the National Abortion Rights Action League, saying, there's 1,100 pro-life laws that have been proposed in the states, it is as good as a statement that Roe and Casey have never been accepted. Mm-hmm. Therefore, no stare decisis. Therefore, the court does not have to be a super legislature and hear all these little line drawings. 6 weeks? 10 weeks, 15 weeks, 1 doctor present after viability, 2 parental consent, parental notification. The court could stop this insane line drawing that's meant for legislatures. To the pro-life movement, the court's legacy, the court's believability, the court's nonpartisanship would be shown by handing abortion back to the states. Tons of states are legislating. I may not like it all. I don't like what Illinois did. I hate what Vermont has done and is continuing to do. But the states are capable of legislating on this. And again, unlike pro-choice, every day is a day in the panic room, the country will go on just fine when the states take this back.
And with respect to the Texas law, since that's getting so much heat right now, unconventional, I want to get your assessment of the decision. Not just a doctor has to check for a heartbeat, cannot perform an abortion if there's a fetal heartbeat, but also there's no criminal exposure, it's civil exposure. So if a doctor were to violate the Texas law, that doctor would be exposed to civil penalties if somebody decided to sue, but no criminal penalties at the hands of the state.
Yeah, that is a decision that states make. I mean, you get... Even before Roe, you had a wide variety of laws because that's what state, laboratories are for, attempting a wide variety of laws. And they're feeling that perhaps the most effective restraint on a doctor is to threaten the massive income that they can make from abortion is the way to go, is one possible judgment a state can make.
Mm-hmm. And it also gives lie to the abortionists' argument that this is about putting women in jail. I mean, there's no legal exposure to women in Texas whatsoever.
Exactly. It's very explicit. And, even really old laws, again, pre-Roe stuff that happened in pretty much every state in the country, did not criminalize women. The understanding of the sort of dead cold panic that a woman in a true crisis feels was always there in the law. And who knows if Roe and Casey are overturned and this is handed back to the states, or even if they're curbed a great deal and we're allowed a lot more regulating at the state level, states could choose criminal or civil, penalties for the doctor. I don't think you're going to see anybody have penalties for the woman, but I think you're going to see a variety of experiments vis-a-vis how to really restrain doctors from getting into this business.
She is Helen Alvaré, professor at George Mason University, Robert A. Levy Endowed Chair in Law and Liberty at the Antonin Scalia Law School at George Mason University. That is. She's Professor Helen Alvaré. Thanks so much for joining us. Appreciate it.
Thank you for having me.
And she joined us on our turnkey.pro answer line.
This is Chicago's Morning Answer.
Your show keeps me alive during the week. There's nobody I'd rather listen to between 5 and 9 in the morning than you guys.
On AM 560, The Answer.
Need new windows, but reluctant to subject yourself to aggressive salesmen, phony offers, or a shoddy installation? There's a better way to shop for replacement windows. Woodland Windows and Doors. New windows can turn an old